Greetings. This is a presentation of Georgia Minimum Technical Standards for Property Surveys. This is part one, covering research, measurements, and monuments. My name is Mark Chastain, and I'll be your instructor. We start with Rule 180-7-.02, Land, Titles, and Location, Part 1A. Understand this is the very first rule under the minimum technical standards for property surveys within the realm of board rules for the Board of Registration for professional engineers and land surveyors. So this is the very first rule, and this is the very first rule for a reason. This was the very first rule long before I was appointed to the board, on which I served for 18 years in 2003. So this is not new. This has been the cornerstone of land surveying in Georgia, or at least supposed to be, for many decades. So this rule begins by saying every parcel of land whose boundaries are surveyed by a land surveyor should be made conformable with the record title boundaries of such land. That means we cannot ignore the record title boundaries of the land. The legal description of our subject property that vests them with title, what we call the vesting description, is what our survey needs to be conformable with. Now, don't despair if it's vague or if it has some issues. We'll come back to that. The rule is actually very comprehensive. But that is important to realize, that our survey is to be made conformable with the record title boundaries of such land, not just of our land, but with the adjoining land as well, because it's all land. So this rule gives us some pretty good instructions. It says the land surveyor, prior to making such a survey, shall acquire the following prerequisite data. Now let's think about what that sentence is saying. Before we start surveying, before we go to the property, we are supposed to acquire the following prerequisite data. Prerequisite means it's required before you get started. Deeds, maps, certificates of title, centerline data, right-of-way data, adjacent descriptions, other boundary line locations in the vicinity, and I've emphasized here, as necessary or available. So sometimes things are not available, but that's subjective. What are land surveyors expected to do? Produce a reasonable effort. What is a reasonable effort? I would say it's up to the level of research that a title examiner would do in a standard search, not in a huge, in-depth title abstract or something like that. But the common surveyor or the common title attorney is required to go back 50 years. Now that's only like 1975. That's not going back into ancient history, and a lot of things happened before then. As a matter of fact, a lot of highways and railroads and power lines and things that will affect these properties took place before then. So it may be necessary, even though not readily available, to go back further. So the land surveyor shall then compare and analyze all of the data obtained and make the most nearly correct legal determination possible of the position of the boundaries of such parcel. So we have to acquire all this data, then we have to analyze it, compare it, make sure it fits, figure out what's going on. Then, step 3, we shall make a field survey. Third phase, the third step of the process is then to go to the property and survey it. Connect all the available monuments appropriate or necessary for the location. Then fourth, we coordinate the facts of such survey with the predetermined analysis, which was step 2. Not until then shall the monuments marking the corners of such parcel be set, and such monuments shall be set in accordance with the most full and satisfactory analysis obtainable. It shall be the responsibility of the land surveyor to evaluate conformity with adjacent tracts for overlaps and gores. Look at this highlight, and to report the same on all maps, plats and reports. What are we saying here? You've got to get everything that you can that as necessary and that is available. Unrecorded plats and things are not available, but as they are necessary and available, we're to acquire everything. Number one. Then number two, we compile them and analyze them. Number three, we go survey. Number four, we coordinate the facts. Number five, we set the corners and draw the plat. So that's where this rule takes us. It does not leave us a lot of room to just take our client's deed or plat and be a deed staker and go locate their pins, blind and oblivious to the adjacent properties. It does not allow us to just survey their possession and say this must be their property. We must go by their recorded title boundaries and compare that to their neighbors. A lot of issues, a lot of problems in Georgia land courts could have been avoided if people had merely gone by this rule to its extent. So let's move to part B of this same rule. So what happens when you can't do that, when the descriptions don't match up, when somebody's claiming some of our land or vice versa? What happens if the deed is so vague and ambiguous that you cannot follow it, that you cannot tell where the title boundaries are? Do you just, if it says 200 yards more or less, do you go 600.00 and drive a pin and hope for the best? No. In the event, this is what the rule says, this is our guidance. In the event that the land surveyor determines that it is not possible to make the survey of a parcel of land conformable with the record title of such land, or that it is not possible to coordinate the predetermined analysis with the fields survey, the surveyor shall explain the reason for his determination and shall denote in indisputable language the source and reason for the corners, lines, and or areas shown on the plat. So let's back up and look at that just a little bit closer. When it's not possible to say everything matches up perfectly and we're good with it, then we still have to make a determination. We still have to set a corner. We still have to make a decision. But we explain in indisputable language. Now, I didn't make that term up, but that would mean that nobody can dispute what you meant. It doesn't mean that there's not going to be a property dispute. It just means that nobody can dispute your language. You explain it in good professional communications, good English language, good grammar and punctuation. This corner was established by using this approach or this method or this record distance, or using these 2 points for line and a prorated distance, or whatever reason that you find to be the best basis, the best reasoning for establishing a corner or a line. And of course, usually if you get into a fix like that, you need to talk to the adjacent owners. And part of your indisputable language might be as identified by adjacent owner John Doe. There are a lot of different reasons and things that you can elaborate. And such reasons may include, but are not limited to, disputed property lines or areas, possession lines. Often possession lines are not where the title boundaries are found to be. You get into acquiescence, which is an extension in current legal atmosphere of possession lines. This is where I've been possessing. I thought it was mine. This is where my neighbor thought the line was. If you feel the need to determine that the line is somewhere besides the title boundary and it's over here where they've acquiesced to, you need to show the title boundary, and you need to show this new proposed adjusted line and make some clear, indisputable language that as to how the property owners need to resolve this, more than likely with a formal boundary line agreement between the two parties. Maybe there's adverse possession. Understand that surveyors do not have the power to move property lines. There are only 3 people who can move property lines. That's 2 willing cooperating owners or 1 judge. So surveyor's not in that list. If it's adverse possession, we need to show it and work on it, but we need to keep 1 foot in the recorded title boundaries and another foot in the indisputable language on what's going on so that everybody understands. If you find some unrecorded deeds, maybe there's a proposed parcel, proposed purchase, that's clear enough and doesn't require a big essay. But if you're cutting 2 acres out of 10 acres, well, part of that boundary is brand new boundary, doesn't conform to a title, current title description. It's new, so that would be addressed simply by saying, this is a division survey. Dubious and nebulous deed descriptions. If you just can't follow that deed, if it just says thence to a red oak and it doesn't give you a direction or a distance or anything else to go by, well, any red oak is as good as no red oak at all. You cannot confirm that it's the red oak in the deed. If you do use a red oak tree, I hope that there's something that leads you to that red oak tree, like it's the only one within 500 feet, or it's got blazing on it, or the subject property owner identified it as the corner. There would be reasons to qualify your decisions in the situations of dubious and nebulous deed descriptions, or any adverse claim. There may be junior and senior rights. Junior and senior rights is one application that's kind of a gray area as to, do surveyors have the ability to move a property line? Well, a senior right or a senior line is a property line. A junior line that's in conflict is just really a mistake. So if we hold the senior line, then we are just adhering to proper title boundaries after we've done the analysis of the research. But we cannot just ignore where the junior line is, because somebody's bought to that. Someone, our client, their attorney, future buyer, lender, title underwriter, is going to look at that. Let's just say that piece of property is supposed to be not 100 feet wide, but after a senior conveyance, there's only 98 feet left, so our survey shows 98 feet. Well, that leaves people to wonder, where's the other 2 feet? Which side is it on? Where did it go? What's going on? So that would be a situation to where our final determination would not be conformable with the recorded title boundary of our property, because it calls for 100 feet. If 98 is where we think the true and correct corner is, because the senior adjacent conveyance took that away first, then we need to say, what I personally do is would show a dashed line at the 100-foot mark and say 100-foot line as described in deed book such and such, parentheses, junior to previous conveyance out of common grantor and deed book so and so. So just indisputable language. It doesn't have to be such that a 10th grader can read it, but people familiar with the property, attorneys and all these other people, they need to be able to read it and understand exactly why. If your title description is 100 feet and you're saying that it's 98, you need to explain to them why. That's simple enough. If you tell somebody to work on your car and get it running as good as new, and they can't because you've got a problem with a computer or a fuel injector or a cam, they just need to explain to you why they've done the best they can, but they can't get it running as good as new. It's just simple business that's not even unique to survey. I'd like to draw your attention to the instructor commentary highlighted here in the bottom. That is the certification that we as land surveyors put on plats, that we have complied with all of the minimum technical standards and board rules in the state of Georgia, that this survey is compliant and meets all those requirements. We are telling the public that we have followed we have followed every rule, not just the ones on closure precision or capping our rebars. We have followed these 2 rules. And so there is a legal presumption that unless we qualify some part of our boundary with some of this indisputable language, they have a reasonable expectation to rely on the plat to be free and clear from all issues, problems, overlaps, any kind of problem that's out there, and that you have, as the land surveyor, personally reviewed every adjacent description, and that you have matched them up and everything is fine and it all fits like a hand in a glove, unless you qualified with some indisputable language and notes somewhere and showed there's an overlap from plat book so-and-so, 1934 or 1994, doesn't matter. So be careful that you don't shortcut this step, or that you do not think, well, we'll we don't want to rock the the apple cart, or upset the boat. We want everybody to get to closing, and we don't want to be the bad guy. Well, you're going to be a lot worse guy if it blows up after the closing. Next, we move on to the measurements. So this presentation is not in chronological order of the rules. It's more by subject matter. So we start with the rule on our research, conducting the survey. Now we're going to talk about our requirements for horizontal measurements. Rule 187 or 180-7-0.03 is titled Measurements Horizontal. So there's a totally different rule about vertical measurements, benchmarks, and topography, which is not covered in this presentation. This is purely about property surveys. So measurements shall be made with instruments capable of attaining the required accuracy for the particular problem involved. Angles and distances shall be measured to obtain an accuracy of not less than 1 in 10,000 error of closure in urban or suburban areas, and 1 in 5,000 in rural areas, except as follows. The allowable positional tolerance of property corners with respect to each other within a given survey may not be greater than 1/10 of a foot in urban blocks where buildings can be erected along the property line or where high land values so warrant, 0.25 foot in suburban subdivision, interior blocks, and or suburban lots or parcels, and 0.5 feet or a half a foot in rural areas. So then there's some exceptions. It says except as follows. So basically what this is saying is a traditional traverse by angle and distance, total station, robot, transit and steel tape, closure precision of 1 part in 10,000 in urban or suburban, or 1 in 5,000 in rural areas. Now, a lot of measurements nowadays are not done with the traditional traverse by angle and distance. And even if you're using an instrument with angle and distance, smaller tracks may not really be necessary to conduct a full traverse. And so we may have to where we have redundant measurements on the same position where we can inverse between them and compute the difference. If we do an instrument traverse, just say occupy 2 different points, shoot a third point, inverse that distance, that would be some positional tolerance by direct measurement, not by statistical analysis. But understand that statistical analysis and standard deviations and root mean squares are something that 12 jurors are not going to understand. Probably get them to understand some XY coordinates, and that when we measured from one point, we got it over here. When we measured to another point, we came over here 4/100ths of a foot away. That's only a 1/2 of an inch, ladies and gentlemen of the jury. Keep that in mind as you prepare your drawings. So State Board has determined that the allowable positional tolerance is 1/10 of a foot in urban blocks, urban areas, downtown. When you're in the suburbs, it's 1/4 of a foot, 0.25. And when you're in the rural areas, it's a 1/2 a foot. Now, understand that it's kind of an either or, and yeah, there's a gray area. If you're surveying a huge, say 1,000-acre parcel, you say 640-acre parcel is a square mile, so it's 4 miles around it. If you have a 1 in 5,000 closure, it means you got 4 feet of bust. Might be in one place. You might have 3 lines measured pretty good. You might have 4 feet of error in one line, but you're still compliant with a 1 in 5,000 closure. That would not comply with the 0.5 foot of positional tolerance. So it's sort of an either or. If you've got 4 feet of bust in a square mile, and you got you'll probably have more than a 1/2 a foot of error, in positional error between the corners, but you've done your job if you got a 1 in 5,000 closure. So if the distances come up worse later, you're not non-compliant. But if you're using GPS or some sort of radial redundant mode surveying, or direct measurement of some lines and angle and distance to others, something like that, then you need to have checks in place to be able to demonstrate that you have obtained these 1/10 of a foot, 1/4 of a foot, 1/2 of a foot tolerances in urban, suburban, and rural areas, in case you're ever asked. And we'll get into some of this more later. So it says except as follows. So these are more along the lines of footnotes. It's in the same rule, 180-7-.03. Little I says closer tolerance is required where land value in rural areas is increased by adjacency to major highway intersections or throughway complexes, building congestion, oil or mineral rights, or any other reason. So if you're in a rural area but you're on a big river where land's selling for 6 figures per acre, closer tolerance is required than a 1/2 a foot. You shouldn't have to be told that, but this is why we have rules. If you're in the mountains with a 100-mile view, and the lots are selling for $500,000 a piece, I would apply the urban or at least suburban tolerance and approach to those parcels, because a 1/2 a foot could create some issues if people are doing small lots and building big houses on them. And likewise, little 2i, when a parcel of land is extremely long or narrow, closer tolerance is required on the shorter, narrow dimensions to qualify acceptable corner positioning in relation to the narrow width. So, say a piece of property is 100 feet wide by 1,000 feet long. Well, if you got a foot in the sidelines that's 1,000 feet long and it's actually 999, that's probably not too big of a deal. That's not even, that's 1 in 1,000, not 1 in 5,000, but just using that for example. But if you're a foot off on the 100-foot side, that's going to be very noticeable. That's probably road frontage, river frontage, railroad frontage, or something. And the same amount of error is going to be a lot more detectable on the narrow side. So pay more attention to the narrow side than the long side when you have to. And this, little 3i is in here because apparently at some point in time back in the annals of history, the rule said it's okay to retrace the steps of the original surveyor. Well, if the original surveyor was 1800s to 1830s, using a compass, staff compass and a gunner's chain, then that means that you may very well need to follow those footsteps and use that same equipment to find the same deviation of the needle, the same effects of the ground terrain on your chain measurements. But that's not a survey that meets these other requirements. So this little 3i is in here to say that where original surveys in rural areas were made with a compass, retracement may be made by compass in order to follow the footsteps of the original surveyor. In other words, the state's not concerned with how you go about conducting your survey. It's the end product that they're concerned with. So it says, however, such retracement also must be reduced to a non-magnetic traverse so that the area of closure as specified above is obtained. So this rule is not really a rule, it's kind of a FYI. If you grab a compass out of your vest and a tape out of the toolbox and you go down through there trying to find somebody's pins and you find them, that's great, you found them. Now it's time to survey. You have not surveyed just because you used a compass and tape. All right, so next we'll move to the rule on monuments, 180-7-.05. Now we take a lot of this for granted, but usually the first section of a rule, or the preamble, is important because it's trying to tell us something and it bears reading. But I can also tell you from personal experience that if something goes wrong and you wind up in court, the attorney, there's about a 99.9% chance that the attorney on the other side is not a land surveyor, but they can read really good. And that's where they're going to start. And if you're being interrogated on the stand or in a deposition, this is where they're going to start. So let's listen to this rule. First part, paragraph 1. In order to prevent boundary conflicts, the public must have assurances that the corners of real property boundaries, as determined from an accurate survey, are durably marked with survey monuments that have been identified on the ground with the aid of the survey plat. In meeting this objective, surveyors must meet the following standards of accuracy, completeness, and quality. So if you're on the stand and you didn't set a corner, didn't cap a corner, or you pin farmed and drove pin number 2, 3, 4, or 5 in an area the size of a basketball, and you're the last one in, then you're the one that's going to be rang up, and either the Attorney General's office through the state board or the other attorney, if it goes to civil litigation, is going to have you read this paragraph from the stand and ask you if you understand that and understand why monuments are so important. Or it may be that you decided not to set a corner because you already got paid, plat's already recorded, nobody's screaming for it. Let's just don't do that. Well, if you didn't do that and you don't have any field data that shows that you did, and the fact that you didn't set that corner leads to problems, which it can if a realtor or a property owner ties up from some flagging. Rebar can be purchased at any hardware store, Home Depot and Lowe's. So it's easy to impersonate a surveyor, and people will use their GPS, their Landglide, their Onyx, and their hunting apps, and they'll figure, well, if there's not a corner here, I'm going to set one. And if they set it 10 feet in the wrong place and a problem resolves or a problem evolves, and it's because you didn't do your job and set your monuments, you're going to be rang up with this same standard in mind. So let's talk about what that standard is. Paragraph 2, the land surveyor shall set monuments as defined herein unless monuments already exist or cannot be set due to physical obstructions. Said monuments shall be set at all boundary corners. These monuments that cannot be set due to physical obstructions shall have a reference monument set. Said reference monument shall be referenced on the plat by bearing a distance from the true position of said monument. Also, said reference monument shall be set far enough away from the true corner so as not to be confused with the position of the true corner. I had a crew chief say, well, we hit a tree, so we set the pin back on line. Setting it back on line is great. How far back? Oh, about 3/10. No, somebody's going to see that and they're going to think that we just got 3/10 of error in our survey, or oh, we're within 3/10. It's a rural area, we're within 5/10, so that must be the corner. No, set it 5 feet back, set it something, and then mark the tree up really good so that people get the idea that the corner falls in the tree, and then denote that accordingly on the plat. So make sure it's not confused. Now, what are our monuments? Paragraph 3, all monuments set shall be composed of a durable material and shall incorporate a ferrous material. If you don't know what a ferrous material is, look it up, but that means steel. It means a metal that can be magnetized and is polarized and can be detected with a magnetic locator, or as we call it in the surveying business, a pin finder. So it shall incorporate a ferrous material to aid in location by magnetic locators. Said monument shall have a minimum length of 18 inches. Longer monuments are required in soils less likely to hold and maintain the true position of the monument. So if it's in some soupy, marshy soil and an 18-inch pin, the last lick knocks it out of sight and you can't see it, common sense should tell you, use a longer monument. You know, keep a 3 or 4 footer in the back of the truck for just those type situations. A lot of times you might not have to go down 3 or 4 feet, but you know, a lot of areas 24 inches is a good length, because you won't leave it sticking up enough to be seen unless it's in somebody's yard. But you need to make them long enough to hold and maintain the true position of the position. Said monuments composed of solid metal rods shall have a minimum cross-sectional area of 0.2 square inches. Now my footnote is that's a 1/2 inch rebar. If you look at a 1/4 inch, radius pi squared, it comes up to like 0.196. Call that 0.2 square inches. So it could be a 1/2 inch rebar, a 1/2 inch rod. There are these big 1/2 inch solid rods they use to anchor curb forms and things. Those are all adequate if they're 18 inches long in this situation. For concrete, composite material, or stone monuments, they shall have a minimum dimension of 3 inches by 3 inches. Monuments placed at landlocked corners, district corners, or county corners shall, if a rod, have a minimum diameter of 5/8 inches, a pipe of 1 inch diameter, or a concrete or stone monument of not less than 4 inches square. So if it's a significant corner, we're supposed to set larger, more durable corners. So that's what we're supposed to set. Now we'll move on to the rest of the rule. So paragraph 4 says that every boundary monument set shall be identified with a durable marker or cap bearing the Georgia registration number of the land surveyor in responsible charge, or the name of the business entity, and or the certificate of authorization number. So you can choose, a lot of these caps simply say LS1234. Some may say LSF 0999 for a land surveyor firm, your certificate of authorization number. You can put the business entity. Mine say Chastain and Associates PC on them, because I'm thinking if we're using license numbers, that's more to let just other surveyors know who we are, who know how to get on the state board's website and look it up. But we're out there surveying for, around, and in protection of the public. So the public is not going to know what LSF 0999 is or who LS1234 is, but they'll know your company name. So we talked about the 18-inch minimum length, the diameter, and the size. But what happens when you can't do that? What happens when the corner falls in the middle of a stream, a river, an active road, a busy parking lot, or a rock outcropping, or a chunk of concrete, or a concrete pad, and you simply cannot pound a 1/2 inch diameter, 18-inch long rod into it? Number 5, if a boundary corner falls in a hard surface, such as concrete or asphalt, well, I got off. Actually, if it falls into a river or stream, we set it back on the line. So to clarify, if the boundary corner falls in a hard surface, such as concrete or asphalt, alternate monumentation may be used that is durable and identifiable. So at that point, it's at the surveyor's discretion. I personally use a good 1.5 or 2.5 inch magnetic nail, and we have washers that are stamped on them with the company name and phone number, just like our plastic rebar caps are. They must be durable and identifiable. The little plastic washer things that you put on some of them are flagging. That's not identifiable, it's not durable. So even though it's not common practice, I will tell you that according to the rule, if you're in concrete, asphalt, rock outcropping, what we try to do is keep a rechargeable drill with a bit in the truck, and we go get the bit and we drill a hole where the corner goes and we sink that nail in the washer. Number 6, for irregular boundaries such as non-engineered roads, in other words, crooked roads. So if you're on a state highway, should be monuments at the PCs and PTs. Should be right-of-way monuments that the highway department set. But if for irregular boundaries such as non-engineered roads, rivers, streams, lakes, a beach, etc., a dimension meander line or survey line may be used. If a meander line is used, monuments shall be set at the meander line's terminus points on the real property boundary lines. So I'm not a fan of that. I'd rather put calls down the stream, down the middle of the swamp, wherever I think, so we can compute an area and everybody understands that work product, and we denote it as, center line of stream is property line. That puts everybody on notice that it's a riparian boundary. It might move next week. If it's a swamp and we've used aerial photographs, remote sensing, old topo maps, old surveys, and this is where we think it is, but the swamp's 400 feet wide, prove me wrong, but here's where we think it is, then at least we're putting people on notice, indisputable language, that, if you drain the swamp and figure out where the thread of the stream is, it might be somewhere different, and it's a riparian boundary, and there we go. So, but if you use a meander line and just show the property line without cause as a little crooked, curvy line, you need to have monuments on the inland or the upland property lines, and the tie call should go between it, because you have to compute a map closure from something. Number 7, all monuments found or placed shall be described on the survey plat. The corner descriptions shall state the size, material, and cap identification of the monument, as well as whether the monument was set or found. So to say IPF doesn't get it. If everything that you found was a 1/2-inch rebar and your legend says IPF equals 1/2-inch rebar, you've actually connected the dots and identified it. I prefer just to say at each corner 1/2-inch rebar found. You can say 1/2-inch rebar set. I like to say IPS where we set a corner, and then my legend says 5/8-inch capped rebar. So I'm still satisfying the size, type, and material requirement that we describe them by. So you can't just say rebar found or iron rod found. We need a size and the material. So on that note, I'm going to skip over to a relevant portion of another rule, 180-7-.07D9. This is from the map and plat requirements. This is regarding monument perpetuation. So let's read this rule. All corner markers and markers of pertinent reference points shall be fully described and indicated. This is what has to go on the plat as to the material or type, size or dimensions, and whether set, found, or replaced. So what does that mean? In the case of a badly disturbed or deteriorated monuments that are replaced for the purpose of position preservation, the survey shall indicate the size, type, and material of both the found monument and the monument with which it was replaced. So, for instance, I'm on Piedmont Avenue in Atlanta, and I get a metal detector reading. I dig down behind the sidewalk, probably a good foot deep, and I find a iron pipe. And son of a gun, it was set in 1908, at least supposedly, and it is crumbling. It's rusted, and as I tap on it and I touch it with the pin finder, it begins to crumble. I want to tie flagging around it, but it's just crumbling. It's the corner, though. I don't leave a pile of crumbled, rusted metal. That doesn't do anybody any good. I go get a rebar out of the truck, cap it, and drive it right there where I found that 1-inch pipe. My plat will say IPS 5/8 rebar at badly deteriorated 1-inch open top pipe found. Then everybody knows what's going on. As you remember from last semester, for a monument to be held as controlling, it must be called for, match the description, and appear undisturbed. So if you're looking based on a 1970 survey where they found this pipe last, and they're calling for a 1-inch open pipe, and then you're retracing and you find my capped rebar, you should approach that with a little skepticism. Plat calls for an open top pipe. I found a rebar. I might need to dig down there and see if there's a, metal detector's not going to give me the answer. I may need to dig down and see if there's an open top down there that he missed. Maybe he set a rebar a foot from the open top or a 1/2 foot from the open top. The open top's still the corner. Now we got a pin farm and a problem. But if your survey documents 5/8, 1/2-inch, whatever rebar, whatever corner you set, at a badly deteriorated 1-inch open top pipe, then you have provided that link. You've got the called for monument of a 1-inch open top incorporated. Now it's where that capped rebar is. So This is something else when it comes to monuments that doesn't get brought up very often, but is very relevant. Now, here's a little known rule that law. This is actually from the Official Code of Georgia, Title 44, Section 115. The destruction or removal of survey monuments. Well, obviously it's prohibited. There are some exceptions and there are some penalties because this is a state law. So the law first talks to geodetic control monuments. So those are, that doesn't take a lot of imagination for surveyors. They're control monuments. Typically they're going to be concrete monuments, but they might be other fixed permanent objects that have been set for public works projects or for other state and federal agencies. So they're not property corners. That's the main thing. Is geodetic control monument is different than a property corner. So usually if it's a metal, brass or aluminum or bronze capped concrete monument, it's probably got a stamp on there that says $250 fine for removal. Well, during the Great Depression, $250 was a lot of money. That's when they set the amount and started capping those. Now $250 is not going to discourage too many people. It can also be applied to if there's a DOT project or a pipeline project perhaps, or some sort of waterline project, and they've set intervisible control points for along a long linear project. Those control points would likely be a geodetic control monument. And so the reason we mention this is if they are removed or destroyed, it's a violation of this law and there are penalties. So that brings us to OCGA 44-115, paragraph 2, property corner monuments. This is where we as land surveyors are most likely going to be encountering any nexus to this law. So under this law, property corner monuments, which we've just studied in great depth through the board rules, but this is what the state law says about them in regards to the Georgia Monumentation Act or Georgia Monument Protection Act. It means those survey monuments which are established to identify property corners, the location and description of which are made a property of any plat or any instrument pertaining to real property filed in the office of the Clerk of Superior Court of any county of this state. So what does that mean? I believe you could make the argument that uncalled for pins on the line might not be protected by this, but I think that would be kind of awry from the intent of the law, because another construction of it would mean they are identifying property corners. So then, comma, the location of the property corner is, the location of the property is recorded in the clerk's office. So I think if this came up, I don't think someone would try to mean that a pin on line or a reference monument is not protected under the law. I've never heard of anybody trying that, but I have been asked, what does that mean that if it's not on a deed or a plat recorded in the courthouse? I think this is kind of vague enough that you could argue it either way. I wouldn't think that would ever come up, but obviously the main point to this law in regards to the practice of land surveying is when you have two neighbors that are fussing and they're pulling each other's pins up. I've been around it dozens of times. People say, well, what can I do about it? He's pulled my pins up. Well, if you can prove it, you can go to the magistrate court or to the district attorney's office, or you can call the sheriff's department. I would not call 911 because it's not an emergency. You'll make them unhappy. But you can come out there and say, he pulled the pins up. He will admit to it. I have him on camera, trail cam, or surveillance camera, or with a video camera. I've seen him out there like it was a Jerry Springer show, fussing and pulling each other's property corners up and swinging them out in the woods. Well, if you have proof of that, that's a violation of the law, just like speeding or anything else. Even though it's not in the criminal code, you could ask that they be charged or a warrant be filed against them for breaking OCGA 44-115. So that's the nexus of it. And of course, it also means that we don't need to be pulling up other people's pins because we're not immune from the law. There are some procedures for land surveyors to be involved in something like this, which is covered on the last slide. But coming back to the law, it says, said survey monuments may be any permanent or semi-permanent objects or any live or dead plant material, including but not limited to iron or steel pipes, bars or rods, concrete markers, including highway right-of-way markers, stone or rock, whether natural or erected, trees, stumps, stakes, and marks, including the marks made on trees, stones, rock, concrete, or metal, and such other monuments as may be described in said plats and instruments of record. So, removing the blazes from a tree is a violation of this law. Cutting down a marked tree could be a violation of this law, especially if it's on the property line where it's considered common property of both owners. Probably have a little bit of conflict there. If I cut down a tree that's blazed and marked and has a sign on it, but it's all on my property, I'm probably going to tell you, mind your own business, I cut the tree down. But you could also come back and say, but that's a marked tree, marking a property line. I could always come back and say it's not marked as being on the line. It's just saying the line is over there somewhere. So you kind of get into a little fussy subjective argument there. But the law itself goes down and says that it might even include trees, stumps, or stakes, or even marks made on trees may be protected property corner monuments under the law. Now, nowhere in the state board rules for monuments do we consider marks made on stumps or markings placed on rocks as being elevated to the level of a monument. We look at it more as a precise, fixed, permanent point on the surface of the earth. But even marks made on trees can qualify under this law. So the last slide, the last part of this section of the presentation is what you would need to know if it comes up is paragraph B. It shall be unlawful for any person willfully and knowingly to remove, destroy, injure, or displace any geodetic control monument or property corner monument, except under the authority of the agency which originally set the monument, or in the case of a property corner monument, under the authority of a registered land surveyor or duly elected or appointed county surveyor, having the written permission of all landowners who are parties to said property corner monument. Never heard of that happening. Now let's go back a few slides and think about this. If you're driving a pin to perpetuate an old position, say you found a rotten locust stake or the rotting rusted iron pipe that I talked about, you're not removing it, you're just perpetuating it. You're not even in the realm of OCGA 44-115. But if you're plucking that pin up, then that's when this law drops in. When would a land surveyor do that? There's only a few instances that I could think of. Say that there's been a land exchange and they're doing some kind of equal area exchange to give somebody more road frontage in exchange for more creek frontage, or to clear a house, or to correct a setback violation or something. And there are property corners that mean something before the transaction that don't mean anything after the transaction. They're all within my property now because I've got this extra 15 feet that used to be my neighbor's. Well, let's take that apart and look at it. That pin's not a property corner anymore. It's a monument, but it's not a property corner anymore. I own all around it. It's my property, just like an antenna or a tent stake or a fire ring. I can go pull it up and move it if I want to. If somebody didn't like it, I don't know who that would be, and they'd have to come over on my property and trespass to prove it. So I don't see that happening. So it's hard for me to understand when it would make sense for a surveyor to simply remove, not perpetuate, but remove a property corner. The one time that I've seen something like that actually happen is when some neighbors decided they were going to regrade an area to make for better access from a road. They're going to cut a big bank down. The pin was up on top of the road. We didn't even have to go remove it. The bulldozer did that for us. We replaced it where it was by using angle and distance from the same control. That was a action that was cooperative between the two property owners. The other thing here that says, in the case, let's read the rest. In the case of a property corner monument, the record of any authorized change shall be filed for record in the office of the clerk of Superior Court. So if you remove it, you're supposed to file a report in the clerk's office. Well, the clerk's office is not going to know what you're doing. It would probably need to be an affidavit affecting the title of both properties and cross-referenced to the vesting deeds of both properties. But again, I can't really think of a time to where there is a need to do this. I can't think of a scenario other than where they're cutting it down. And I guess it would be a good idea, perhaps a requirement to record something that says, the 2-inch pipe that used to sit on the bank of Podunk Road is now a capped 5/8 rebar because they cut the road, they cut the bank down 15 feet. That's a gray area, but that's what the law says about it. The main thing is it's unlawful to pull up corners. And if the people that were around are pulling up corners, sometimes you have to remind them that, you're breaking the law. And this paragraph C here sums it up. Any person who violates this code section shall be convicted or shall be guilty of a misdemeanor, and upon conviction thereof shall be fined not less than $100 or more than $500, and may be punished by imprisonment of not less than 30 days or more than 60 days. So that person who pulls up your client's pen and slings it in the woods and beats his chest and says, yeah, I did that, what are you going to do about it? He could very well be looking at a minimum sentence of 30 days in the county jail. Wow. So that concludes part 1 of Georgia MTS, Research, Measurements, and Monuments. Hope you enjoyed it. Thank you.